let's take a look at what we have here in the form of this news report from Fox TV just a few days ago. Father and son farmers charged with killing armed trespasser. Rural South Carolina farmers charged with killing an armed trespasser were defending their land and their livestock from an uninvited intruder who arrived with a deadly weapon, according to their lawyers. Ryan Jordan Lindler Sr., 52, and Ryan Lindler Jr., 26, allegedly gunned down neighbor Kevin Lester Newhouse, 36, during a confrontation, according to the Lexington County Sheriff's Office. It's going to come down to property rights, vandalism, a history of trespassing, the right to defend others, said attorney Eric Bland. Eric Bland in South Carolina. I wonder if this is the same Eric Bland that spouts so much nonsense on Twitter. I bet it is. Because this doesn't look good for his clients. It seems like what Twitter Eric Bland would be talking about. We'll get back to that, I suppose. Eric Bland, whose firm Bland Richter is representing the elder Lindler. I guess the son's going to have his own lawyer. All things that property owners guard for and against. People in Lexington County, South Carolina, value their property, and a lot of citizens respect each other's property. I don't know what that's got to do with the use of force law, but whatever. Both father and son intend to fight the charges vigorously, lawyer Bland said. The younger Lindler is engaged to be married in 3 weeks, Bland said, and the trespassing occurred at the home he is building with his fiancée, which is about 85% complete. I don't know what that has to do with this case. These cases will test the right of a property owner to protect their property from trespassers and vandals, including those who may bring deadly weapons onto the property of another. Bland Richter said. That's the law firm. Bland Richter said in a statement Tuesday. The sheriff said over the weekend that the elder Lindler disarmed Newhouse before telling his son to shoot him. Well, that's a little awkward for the defense. Quote, over the course of their investigation, which included interviews with both Lindlers and witnesses, detectives determined the elder Lindler told the son to shoot the victim. Lexington Sheriff Jay Kuhn said in a statement. The shooting happened after the elder Lindler had taken a machete away from the victim, who was unarmed when he was shot, and lived near the Lindlers. Newhouse tried to get into his house before the shooting, but the elder Lindler allegedly blocked him from doing so, according to court documents. The younger Lindler told police Newhouse swung the machete at him and his father, striking each of them during the altercation. I don't know if you've ever seen an injury caused by a machete, folks. I can tell you I've seen a machete buried halfway through the very thick neck of a pig with one stroke. So generally, machete injuries are pretty traumatic. But the son says that the victim here, Newhouse, swung the machete at him and his father, striking each of them. That's when the son is accused of firing 3 to 4 rounds from a Glock handgun. At least one shot fatally struck Newhouse in the head. Both the handgun and a machete were recovered during a search of his truck. I hate it when they use pronouns like this. Who's his? Both men, father and son, faced murder and weapons charges and were being held without bail. They've since made bail, by the way, a couple days after this news report. Bland, whose firm represented several victims of the convicted killer and fraudster Alex Murdaugh. Oh, it is that Bland. Hey, Eric. Said the Lindlers have been longtime law-abiding citizens who grow hay and raise cattle in the rural community. Newhouse lived near their farm. Quote, their father and son, who have zero criminal background, both of them graduated from Gilbert High School. The son has had nothing ever in his background ever, other than a speeding ticket, not even a detention at school. A great deal transpired between the alleged trespassing on the Lindlers' property and the deadly confrontation with Newhouse. Blah, blah, blah. This is a tragedy all the way around, not only Newhouse and his family, but for the Lindlers and their family. Yeah, I guess it would be, especially for the dead guy. Let's see, you've got the incident report here. Names the victim. A death occurred on December 6th. Let's see. I guess the redacted name here Under other involved must be a witness. All his property is redacted. These would be mostly vehicles, I suppose. And let's see, is there anything informative here? Ryan Lindler Jr., Ryan Lindler Sr. Oh my gosh, look at these redactions. Very unhelpful. All right, here we go. Let's see. Lexington County CC, must be law enforcement, advised that they received a call saying that a male had been shot in the head and that people were fighting. I arrived on the scene. So this would have been, this is a police officer, presumably. Officer Sharp. Officer Sharp arrived on scene and went toward the back of the residence and located a male, later identified as Kevin Newhouse, lying on the ground. Deputy Brazel and Deputy Aiken were attempting life-saving measures. There were 3 females on scene, and one of them redacted, and I escorted them off of the property. I then heard Deputy Apgar put up crime scene tape and start a crime scene log. Deputy Aiken was gathering witnesses and watching the front of the scene. The FTO ML, so that would be field training officer, had the deceased body and back of the residence cover. I then went and spoke with Ray Lindler Jr., who's the one who shot Kevin Newhouse. Ryan explained that he witnessed Kevin on his property with their cameras and came to this address with his father, Ryan Lindler, father, to confront Kevin. Ryan explained that they started talking to Kevin, but he didn't say much, but explained that Kevin grabbed a machete and started to swing at them. Ryan explained that his father was hit, and so was he. Ryan then explained that he took out his gun and shot Kevin. Ryan stated that people started to come out of the woods, so they left. Ryan explained that he also called 911 about the incident. Ryan did explain that the gun and machete were in his truck. This information was passed on to detectives. Ryan had a 6-round Glock magazine in his pocket. The magazine had 5 Venom 9P VNM rounds. Oh, good Lord. Don't do that, folks. And 1 Luger 9mm round. The magazine was tagged into evidence. I then called Major Crimes and advised them of the situation. I spoke with Watch Command and Region Command about the situation as well. Major Crimes, Coroner, Watch Command all arrived on scene. I was relieved by night shift. My body-worn camera was activated during this incident. That's the whole police report. And then we have the arrest warrants. Another law enforcement officer swore out an affidavit for the arrest of Ryan Lindler Sr., alleging that on December 6th at approximately 4 p.m., while in the rear of this property, which is in the Lexington area of Lexington County, South Carolina, the defendant, Ryan Jordan Lindler Sr., did with malice aforethought tell a co-defendant, his son, to shoot the victim, Kevin Lester Newhouse, after the defendant disarmed and had taken a machete away from the victim. The defendant also prevented the victim. Let's see. Sorry, folks. I forgot to switch it over. Here we go. I'm reading this this paragraph here near the top of the screen. Boy, that's hard to see, huh? Let me do this. That Ryan Jordan Lindler Sr. did with malice aforethought tell a co-defendant to shoot the victim, Kevin Lester Newhouse, after the defendant disarmed and had taken a machete away from the victim. The defendant also prevented the victim from entering his residence prior to the physical altercation. The defendant admitted post-Miranda that he and a co-defendant confronted the victim about a trespassing incident. During a physical altercation, the defendant instructed the co-defendant to shoot the unarmed victim. These facts are supported by witness statements, defendant and co-defendant statements, evidence on scene, and the incident report. And then the arrest warrant for the son who fired the shots. On December 6th at approximately 4 p.m., Ryan Lindler Jr. did, this is just the weapons charge now against the father still. He did commit the crime of possession of a weapon during a violent crime by committing the crime of murder. Murder is defined by statute 16160 while armed with a machete that was taken from the victim, Kevin Lester Newhouse. he instructed a co-defendant to shoot the unarmed victim. And now we have the son on December 6th, 4 p.m. Ryan Jordan Lindler Jr. did, with malice aforethought, shoot and kill the victim, Kevin Lester Newhouse. The defendant admitted post Miranda that he and co-defendant tracked the victim to the victim's residence and confronted him about a trespassing incident. A physical altercation took place, and the defendant fired 3 to 4 shots from his Glock semi-automatic handgun, which struck and killed the victim. The handgun was recovered after a lawful search warrant of the defendant's pickup truck. And then they'll have the weapons charge against the son, too, for being in possession of a weapon while they committed the underlying crime of murder. By the way, this represents a very different narrative, doesn't it, than the media report? The media report made it sound like what? Like this father and son confronted Newhouse, the victim, on the property of the father and son. This arrest warrant says that they observed Newhouse trespassing on their property, but then they went to Newhouse's residence to confront him. And that's where the altercation occurred. So at the time they confronted Newhouse, Newhouse was not in the moment trespassing on their property, on the Lindler property. It sounds like to me that's going to make for a tough defense. None of this is great. And the venom ammo, folks, from the incident report, this, please don't ever do this. Don't buy, don't make use of products or services for what's intended to be lawful self-defense. That's marketed with branding that can suggest a state of malice on your part. That's crazy. Venom 9P VNM rounds. You think they really work better than whatever ammo the FBI carries or the local police department carries, their normal hollow point, their gold dots or whatever they use in their 9s? No, folks, it's no better. And it just makes you look terrible. The prosecution's going to talk about this venom ammo 1,000 times in the course of this trial. He's going to eat that up. All right. Well, I had not looked at the arrest warrants before I started the show, folks. But obviously, if they were on this other gentleman's property, on the victim's property when the confrontation occurred, then they were not using force to prevent a trespass. The trespass was over. You certainly can't use force to seek vengeance for a simple trespass. Then you'd have to believe that their force, if it was not being used in imminent defense of their own property, which it was not if they were on the victim's property, then their only justification left for them to use deadly force would be self-defense, that they were facing an imminent threat of death or serious bodily injury. And that's what they claim, right? They claim that they were attacked with a machete. They also say that the victim here somehow secured the machete. So he wasn't carrying it on his person. He secured it, struck them with it, and that's why they shot him. But the witnesses say they shot him after the victim was disarmed of the machete. Now, are we seeing anything here that would suggest that the version of the facts being presented by the father and son is consistent with the evidence? Do they have injuries caused by a machete strike? I mean, you could lose an arm from getting hit with a machete. But their lawyer, Eric Bland, doesn't describe any injuries. Nobody describes any injuries to these guys, senior and junior. Eric Bland, the lawyer, talks a lot about property. It's going to come down to property rights, vandalism, a history of trespassing. None of that has to do with self-defense. You think if his clients were attacked with a machete, he'd be talking a little bit about that as the justification for why they shot their neighbor? But the lawyer's not. Their own lawyer's talking to the media. He's talking about the son's getting married. He's building a home that's 85% complete. What's that got to do with anything? Now, granted, the lawyer, even if it's Eric Bland, the lawyer's stuck with the facts his clients give him. But if he had good facts, I expect he'd be talking about them in this news report, in this report statement he gave to the media. Now, there is a little bit of a wrinkle here in all this, in that South Carolina use of force law is terrible. I mean, it's not necessarily substantively terrible, but there's basically no statutes on self-defense, defense of persons law in South Carolina. And this is not the only state that does this. Massachusetts also has essentially no statutes on self-defense law. It can happen in these old states, the original 13 colonies states, and they've just never gotten around to codifying self-defense law. Now, they have self-defense law, of course, and it's not that different from other states. It still follows the same fundamental 5 elements of self-defense, but it's all in court decisions, in case law, in common law. It's not in statutes. So you can't just go look up the South Carolina statutes on self-defense law. Where do you find the law? Well, you'd have to go read the appellate court decisions. And of course, the appellate court decisions are distilled down into jury instructions.